Ms. Nimoy. Now we'll hear from Ms. You may approach the lectern. You have up to 5 minutes. A very good morning to you.
Good morning, Your Honors. And for the record, Ms. Willis-Newton.
That's correct.
May it please the Court, Joanne Willis-Newton on behalf of the father, J.E., who is not present in order to protect the privacy of the family. I stand before you as a citizen of the United States and Canada and the Cree Nation of Tisasapi. I am 100% American, 100%
Now,
Canadian.
what are you giving us now? I'm sorry.
I'm sorry, I'm just starting with my presentation here.
Okay, I'm sorry. Okay.
And 100% Tisasapi Cree. Grateful to my Cree ancestors for their use and occupation of our traditional territory, which secured me the education rights that allowed me to obtain my law degrees and devote my career to the advancement of Native American rights. In my experience, the Indian Child Welfare Act continues to fall victim to a bias against legislation that provides unique rights to Indian people. This bias reflects a lack of understanding about tribal sovereignty, the government-to-government relationship between the U.S. government and tribes, and the need to remediate the effect of past failed federal policies, which have resulted in the breakup of generations of Indian families. Fortunately, our legislature in California understands this and codified all of the provisions of the Indian Child Welfare Act as state law. The Indian Child Welfare Act represents best practice for all children at risk. The Act is about avoiding removal whenever possible, keeping children within the family circle when removal is necessary.
Can I ask you a question, Ms. Willis-Newton? It was adverted to in one of my orders, and that is what standing do you, and you're here because you were appearing in the trial court and you have a right to be here, but what standing does your client have in terms of expressing an opinion or a view, not on these important federally articulated and also California enacted principles, but what standing does your client have to offer any views concerning the welfare of the child, putting aside his past extraordinary misconduct?
Well, Your Honor, of course, his parental rights remain intact. They have not been terminated.
Why is that? How did this happen? He gave up all interest in this child years and years ago. How come he's still a party here? I'm at a complete loss as to why 5 years after he has abandoned a child, he has standing to make any argument in an appeal. I understand his rights haven't been terminated, but why haven't they?
Well, Your Honor, that's a very good question. And the fact is, when we allow foster families to don the cloak of de facto parent status and hijack the time frames for juvenile dependency proceedings...
That's not the question I'm asking. I'm asking why his rights were never terminated years and years after he abandoned a child.
I'm attempting to answer that, Your Honor. It's because of these interim placement proceedings that have dragged on now for since 2012.
So is there a legal impediment to termination of his rights at this point?
Not that I'm aware of, Your Honor. It's just that the juvenile court has been occupied with implementing the remand instructions of this court and trying to determine the placement issue. So the 2-6 hearing, Your Honor, has been trailing this entire time. With regard to the father, though, I would just like to say, he made a difficult decision in September 2012.
His conduct is reprehensible. I don't agree. First of all, I genuinely respect your presentation of the arguments here. I'm not being critical of you. But your client's conduct is reprehensible. And to say he made some difficult decision, he's made bad choices all along in terms of the way he conducts his personal life, the manner in which he conducts his disobedience to the laws of our state. Putting aside the legal issues and the timing issues which we've talked about, but why would it matter? Why would we give great weight or any weight at all to somebody who has abandoned the responsibilities of being a father? That's a hard question, but give us your best assessment on it.
Your Honor, I'm not here to defend the father's conduct, but the juvenile dependency system is not a punitive system. The fact is, he did at some point tell the department, please find another family for my child. I can't do it. And we can judge him for that, we can punish him for that, but the fact is he made that difficult decision in 2012, and he designated his family, his cousin, to care for the child, and parents in all of juvenile dependency cases, ICWA or otherwise, have the right to relinquish their children and designate the adoptive caregiver for their children. He has standing.
So there's no question here that the family is the family who the child is with now related at all to your client?
There's no question, Your Honor. It's clear in the record. And the ICWA does not require that the extended family be Indian. The matter of extended family is left to the tribe to determine. The father has standing also because in looking at whether good cause exists to depart from the ICWA placement preferences, the court must consider various factors. And those do include the request of the biological parents. And I would refer Your Honors to the new BIA guidelines, 80 Federal Register at 10158, Section 5.F.4, Paragraph C. Also the Welfare Institution Code, 361.31, Subdivision H.
You've exceeded your 5 minutes, but I'll give you a minute to conclude.
Thank you, Your Honor. I would just ask the court to consider why we're here today after this length of time. As I said, the father has raised the standing issue of the foster parents repeatedly in the former appeal and in this appeal, and I would just urge the court to assess those authorities and determine if, in fact, foster parents should have standing to appeal a placement decision so that we may avoid this situation for other Indian children in the future. We have to keep in mind that this is a county which had no preferred placements available for any Indian child. So we're talking about all Indian children in LA County who will be placed outside of relative care.
Ms. Willis, thank you for your